everybody, and thank you so much for joining us today. My name is Nina, and I'm a lawyer and project coordinator at the Community Legal Education Association, or CLEA. For those of you who aren't familiar with what we do at CLEA, we are a not-for-profit charitable organization, and our mission statement is unknown rights are not rights at all. We've been working to improve access to justice by providing information to Manitobans about their rights and the law, and we've been doing this since 1984. So this means that we are looking forward to celebrating our 40th anniversary in just a couple of years. Before we get started, we would like to acknowledge that CLEA's office is located on Treaty 1 territory, the traditional territory and ancestral lands of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and the homeland of the Métis Nation. Our work extends through Treaties 2, 3, 4, and 5, and we further acknowledge that Northern Manitoba includes lands that were and are the ancestral lands of the Inuit. Today's webinar is a part of a series of webinars we offer twice per year on a variety of topics, and today's topic is going to be child protection with David Joycey. Just as a bit of housekeeping, today's presentation is being offered in webinar format, which means that everyone is muted with their cameras off by default. We will have dedicated time for questions at the end, but please feel free to ask questions during the course of the presentation by using the chat or Q&A functions in Zoom, and we'll do our best to monitor those sections throughout the presentation. I would like to now take a moment to introduce our presenter and facilitator for the evening, David Joycey. So unfortunately, you can't see him today, but David Joycey has 28 years of legal experience practicing both as a supervising attorney with Legal Aid Manitoba and as a member of the private bar. With a career that spans the Atlantic, Mr. Joycey, a graduate of Cambridge and London universities, worked as a teacher in England before emigrating. Arriving in Canada, he taught grades 5 to 8 in a 2-room schoolhouse in Northern Ontario before being ordained as a United Church of Canada minister and serving a rural pastoral charge in the Ottawa Valley. Hired by the Children's Home of Winnipeg, now New Directions for Children, Youth and Families, Mr. Joycey relocated to Winnipeg, where for several years he was a program manager, writing proposals for innovative client-specific programs, and supervising staff in specialized placements. Finally, Mr. Joycey entered law school at the University of Manitoba and was called to the bar in 1994. Since retiring from Legal Aid Manitoba in 2015, Mr. Joycey has continued to make child protection a major part of his practice, representing both parents and children opposing child welfare agencies' applications. It is his belief that this area of law offers unique opportunities to develop skills of communication and negotiation, which are invaluable assets for any practitioner. So this evening, Mr. Joycey is going to be covering various topics related to child protection. And with that being said, it is my pleasure to turn it over to Mr. Joycey. So go ahead.
Okay, so a couple of things to start with. First of all, I'm absolutely thrilled that the camera doesn't work on my computer, because that means that I don't have to look at myself at all, which is always nice. I can't see any of you. I don't quite, to be honest, this whole Zoom thing is something that with which I'm really not terribly familiar. I'm absolutely incompetent when it comes to technology. I'm hoping that everyone can hear me. I had originally understood that I was going to be the co-presenter tonight with one of my colleagues. Evidently, that's not the case, and so you just have me. Now, originally, my understanding was that you would all be lawyers, and I had anticipated that you would probably be lawyers who are practicing in other areas and were interested in possibly doing some child protection work. So my presentation is very much geared for that. Now, I was advised just a week or so ago that, in fact, most of you are not lawyers, which is great to hear. But I would be really interested to know what the other attendees do as opposed to practicing law. It would be very helpful for me to know that right up front, so that I can kind of gear what I have to say towards what might be your interests. And also, if there are particular things that you would like to know about, given that child protection is a pretty broad area, it will be helpful again for me to know that, so that I can sort of present in a way that I think might be helpful. Now, I don't know, is there any way, Nina, that people can speak now at this stage?
Yeah, I've just put in the chat that if anybody is comfortable sharing what it is that they do for work, please do let us know. And if there are any topics in particular that you're interested in, definitely let us know in the chat. And otherwise, if you feel more comfortable speaking, then you can use the raise hand function on Zoom and I will allow the person to talk. So for now, it doesn't seem like anything is coming in, but hopefully somebody will.
Hey, everyone just wants to see me proceeding, not knowing where I'm going. So I will do that, and at least there'll be some entertainment value for everyone.
Well, for the record, we do have a couple of lawyers present at least, and it seems like a lot of the other people present are from various not-for-profit organizations, women's shelters, newcomer organizations, and things like that. So hopefully that helps a little bit. Okay,
so bearing that in mind, I'm going to begin in a different way than I had originally planned, because I'm assuming that most of the people present are people who represent in one way or another, or advocate for in one way or another, people who are likely to be the clients of lawyers in the child protection area. So let me begin by saying that if you have a client or someone that you're advocating for who possibly needs assistance, whose child has been apprehended, child or children have been apprehended, or who anticipates that their children may be apprehended, or someone whose children have been apprehended perhaps a long time ago and have been in the care of an agency for many years, and they're now wanting to be reunited with those children. In any one of those scenarios, you should feel free to contact one of this very small group of lawyers who practice in the child protection area. And if you don't know any others, you're certainly more than welcome to contact me. And if I'm not able to be of assistance, I would certainly be in a position to point you in the right direction, give you contact information for a lawyer who might be able to assist. And it's always better to make that sort of inquiry. And sometimes just by a conversation on the phone, if someone contacts me in that way, and they often do, sometimes just a phone conversation can end up with me pointing them in the right direction, giving them a particular aspect of child protection work that with which I'm not involved. Then I would simply provide a name or a couple of names of other lawyers and phone numbers. Or it might be that I would say, well, make an appointment and come in for a free consultation. And that sometimes works best. I had a fellow come in today to meet with me, and just based on our brief phone conversation, I didn't really understand what it was that he was wanting help with. But in 20 minutes of just talking face to face, which I much prefer, incidentally, than the Zoom and all the other strange ways we've developed of interfacing with each other during COVID. In just a matter of minutes, we were able to work out, first of all, that he doesn't really need a lawyer at this stage, but secondly, how he should approach the agency in a way that might be most helpful. And usually when I give this kind of when I give this kind of advice, just in the context of, a free consultation, I will suggest to the person that when they do contact the agency, it might not be a bad idea to say that they've spoken with me and that I've suggested they contact the agency. It just kind of gives that little bit of reassurance for the person who's making the contact with the agency. And it also lets the agency know that they're not totally on their own, that they are in fact in contact with somebody who knows their way around the system. And often things can be worked out without the involvement of lawyers. The whole notion of child protection issues being resolved in the courtroom is a difficult notion to grasp. I refer to it as trying to do microsurgery with a baseball bat. I mean, the courtroom is set up as I'm sure you all know, in a very adversarial way, with the agency, child protection, the agency lawyers on one side of the courtroom, the parents' lawyers on the other side of the courtroom. There may be counsel appointed for one or more of the children there as well, and then there's a judge or a master who makes decisions. But wherever possible, my advice to people is try to stay out of the courtroom. And that doesn't mean not to involve lawyers, because very often lawyers can be your best guide through the system. Most of the scenarios with which we're presented are scenarios with which we are well familiar. And, we know the jargon, we know the people, we know how the different agencies operate. And so it's always helpful to contact a lawyer, but wherever possible, if things can be resolved without recourse to the courtroom, so much the better. Things have really changed over the last, I was going to say 20 odd years. It's getting closer to 30 odd years that I've been practicing. And when I first started practicing in the child protection area, almost everything, but a lot of matters were set down for trial. It was a case of, if they can't be resolved pretty quickly, then you just set trial dates. What happened, in fact, was that very few of these trials actually proceeded, and most things got sorted out without going to trial. And that's preferable, because a trial really is no place except in extreme situations when all other options have been canvassed to resolve a child protection matter. These days, things are very different. For the last number of years, a whole new process has been put into place. And although I was one of the people who had some real doubts about whether or not it would work, it does seem to be working, and it does seem to be getting things resolved much more effectively and quickly, and in the best interests of the children. And of course, the best interest of the child is the guiding principle behind all child protection work. So maybe be an idea if I just quickly run, although I say quickly, I should probably talk as slowly as I can, given that I'm now the only presenter when there was two to start with. But if I can just run you through the court process. So it begins if a child is apprehended, the agency must provide the parents, guardians, with a court date, and they should appear on that first court date. Now, that begins a rather interesting process, where I've made a note to myself about overview of the court process from the parents' perspective. I've got in brackets beside the weird, the wild, and the wonderful, because it really is pretty weird. It starts with attendance at this court that's called a docket court. Now, for those of you who are not lawyers, I could almost guarantee that you're not familiar with the word docket. I remember telling a friend of mine that I had to attend docket court, and she said, "What the heck is docket court?" Now, this person it comes from an artistic background and tells me, and I have to believe her, that she thinks in pictures. So I said, "Okay, what's the picture that you conjure up in your mind when you hear docket court?" And she said, "Well, it's like I don't know, it's like the village square thing." The village square? What do you mean? Well, you know, where in the medieval times, you know, if someone was found guilty of some minor infraction, they had to go to the village square, and then they put their hands and their feet and their head through this kind of wooden contraption, and then the locals went and threw rotten vegetables at them. I said, "Oh, you mean stocks?" He said, yeah, stocks. I said, "No, it's weird, but it's not quite that weird." It's weird, though, in other ways, because very often parents whose children have been apprehended will attend this court date, and they'll think that they're going to have a chance to speak to a judge. They think that maybe some decisions are going to be made, and none of that happens. Actually, nothing happens on that first appearance, except that their appearance is noted. And if they have a lawyer, that lawyer goes on the record, and then the whole matter is adjourned, usually for 2 weeks, for the agency to provide in writing the history of the agency's history with this family, and the things that led to the apprehension, and also to let the parents know what they're applying for. Are they applying for a temporary order? And if so, is it a 3-month order, a 6-month order? Or are they applying for a permanent order? Or are they applying for an order of supervision? So all of that will come to light, but not on that first appearance. And so that first appearance, parents who are desperately wanting something to happen find that, well, nothing happens, it just all gets put over. Again, it is always helpful for people to have a lawyer, particularly at that initial stage, because once the lawyer has gone on record, then the parents don't have to keep on attending court on each of these adjournments. The lawyer can appear on their behalf, or the lawyer can contact the agency lawyer ahead of time and just have the matter adjourned again if nothing much is happening. Unfortunately, the parents will be given not only a courtroom, an address of the court and the courtroom, they'll also be told what time they have to be there. And that's usually 2 o'clock, 9:30 in the morning, 2 o'clock in the afternoon. And so they arrive and they find the courtroom, and oh, there's the courtroom. Guess I can go in. Well, if they start to go in, they're very quickly stopped and told, no, you have to wait. And then we come to the other weird thing about the child protection docket court. It's not just the name. The child protection docket court is a closed court. That means that nobody can be in the courtroom except the judge, who they call a master. That's another weird thing. You've got the person who looks like a judge sitting up the front, and they're called a master. Very often those are women, but they're still called masters. As I said, it's a weird setup. But so there's the master at the front, there's the court clerk, there's the agency lawyer, and then there are the parents or the lawyers for the parents on each case. And each case goes in one by one. Meanwhile, in the hallway outside, you've by now got quite a mass of people. You've got the social workers that are involved in these cases. You've got the parents that are involved in the cases. You've got the lawyers. You've got some legal aid duty counsel who are there to help people who arrive without a lawyer and want to apply for a lawyer. And sometimes you even have some children over the age of 12 who have to attend court to have their rights heard. So you've got all these people sort of milling around, just waiting and waiting and waiting. And that wait can sometimes be for 2 or 3 hours. So that initial court appearance is so much easier if people have a lawyer, because once they've got a lawyer, the lawyer can appear and they don't have to spend all that time waiting around outside a courtroom to go in and actually on the first or second appearance or so have nothing much happen. Now, having said that, some parents want to go in. They want to be involved. They want the judge, the master, to see that they're there and so on. And if they do, then of course it's very important that whether they have a lawyer or not, that they are allowed to go in and feel that they are part of the process. The docket court deals with matters that can be dealt with quickly. And very often what happens is after that initial appearance, there's an adjournment, and then hopefully the parent or the parent's lawyers are provided in writing with the agency's position. And then the lawyer meets with the parents and goes through the agency expectations and finds out where the parents are in their, often in their rehabilitative process. And then the lawyer is in a position to speak with the agency lawyer and see if perhaps a shorter time could be negotiated. Perhaps there are things that the parents have done, good things that they've done, courses they've taken and so on, that the agency is completely unaware of. And so all that exchange of information takes place. And again, it's so much easier for the parents if they're represented by legal counsel. Should perhaps just mention that nobody should be precluded from having a lawyer on financial grounds. Many of the people whose children are apprehended, when they apply for legal aid, find that they are in fact eligible for legal aid. The sort of maximum earnings changes from time to time, but it's always worth making an application to legal aid. Because if they meet the financial criteria, anybody whose child has been apprehended and is in that child protection court automatically qualifies for a legal aid lawyer to be appointed for them. You know, if people don't qualify for legal aid, then, you know, those of us who practice in this area we're certainly not there to become wealthy. I know I can only speak for myself in this regard, but I'm always more than willing to work out something that that people are comfortable with when it comes to a fee. So it really is worth having a lawyer. The thing is that if parents are self-represented, there's less inclination on the part of the agency, I think, to provide those things in writing. And also, obviously, we as lawyers deal with this all the time. We actually understand what's written, you know, a lot of it being jargon, and some of it being fairly incomprehensible, I think, for a parent who is, after all, probably very stressed, distressed at having been separated from their children. Now, if things can't get sorted out in that 60 days that you're allowed to remain on that docket court, then matters are adjourned to what's called an intake list. And here's, again, it's pretty wild. You've got, you've been in the process for 60 days, and now you're going to an intake list. I don't know who comes up with these names, but it does seem to me a little strange that you have intake court 60 days after you've already been dealing with the matter. Anyway, that's what they call it, intake court. Now, intake court is something that was brought in with this new system that we're operating under now. And I have to say, it's very effective. In preparation for that intake court, the lawyers meet with the parents, and the lawyers write a brief. And essentially, brief is exactly what it sounds like. It is a brief explanation of where the parents are, what their concerns are about what the agency wants, what they've achieved so far, and providing the various certificates and so on, and the point at which the agency and the parents' lawyer are stuck. What is it left that they don't agree about? Is it the length of the order? Is it the some of the things that the agency is wanting the parent to do during the order? Those sorts of things. Most of the time can get sorted out at intake court, because at intake court, you do have a judge, a Queen's Bench judge, the family division judge, and that judge listens off the record to the position of the parents, the position of the agency, and encourages some conversation between them. And I was surprised, a couple of us met recently with the Assistant Chief Justice, and she told us that 84% of the matters which go to this intake court are actually resolved at intake court and do not proceed from there to trial. Usually, everyone walks away feeling, well, the right thing happened. The little bit of give and take on each side, and compromises are reached, and then that judge is in a position to make an order. In the very few cases that things cannot be sorted out at that stage, they proceed to either a trial date with a pretrial conference ahead of the trial. And again, the pretrial conference is another opportunity to appear before a judge and try again to get the matter resolved without going to trial. I understand, and I was quite shocked to hear this, that only about 4 matters, child protection matters last year, evidently, did actually proceed to trial. And trials are never pleasant. Trials are extremely stressful for the parents, and really are a last resort. Not to say they don't serve a purpose. I was involved last year in 3 trials, all of which were very, very stressful and hard on my clients. 2 of them, really, the agency got exactly what they were asking for. My clients had a really hard time, and it was a painful experience for them. One of the others was we had some success. We were able to find some real weaknesses in some of the conclusions that the agency had reached based upon an assessment by an expert. And frankly, that assessment was a very weak assessment. So we were able to come away with something that our clients, the parents, felt very good about. But that certainly is exceptional in these sorts of cases. What else have I got here? Oh, dealing with agency counsel. For the lawyers who are not familiar with the child protection work, it really is unlike anything else, insofar as there are a very small number of lawyers who practice in this area. We all know each other very well, and there's an incredibly high level of mutual respect and trust. It's not like criminal practice, which I've done quite a lot of during my career, where criminal practice, the defense counsel, your job as defense counsel is to get your client off, come what may, and the Crown is there to prosecute and see that justice is done. A very, very adversarial system. I think the most adversarial I've seen, and I only saw it briefly, I articled with a family firm, and about halfway through my articling year, that's the year you do after law school before you're called to the bar, about halfway through, just about the time that law firm told me that they wanted to keep me, I decided there was no way I wanted to practice family law, whatever I did, because there you really are dealing with two individuals who are fighting with each other over, everything in the kitchen sink. Very, very adversarial. The child protection bar is not like that. The child protection bar, we are all very much aware, whether we're agency lawyers or whether we're representing the parents, that we're there for the best, to see the best interests of the children be done. And for counsel for the parents, that often means helping the parents to come to terms with the fact that they're not going to be reunited with the children unless they do. And having to persuade parents that it's not about showing how many mistakes the agency has made, because often the agency has made a lot of mistakes along the way. Agency is just made up of people, and we all make mistakes. But it's not about that. It's not about if you're a lawyer for a parent, or if you're an advocate for a parent, bringing a parent to meet with a lawyer, it's not about what's in the best interest of the parent, except in relation to what's in the best interest of the child. And often it requires a real change in thinking for the parents in order to accept some of the hard realities of their situation. And the lawyer's job, much the same as those of you who are advocates for people whose children have been taken away, much of the lawyer's job is in supporting the parents through that process of coming to terms with how things are, in the hope that that's going to be the first step in moving towards how things can be. Most of these parents are in real pain. They've had their children removed from their care, and whatever kind of care they were able to provide, it doesn't matter. The children were still in their care, and having them removed is an extremely painful and traumatic thing. And so when we're dealing with parents, we have always to bear that in mind. And I often deal with parents whose pain is coming out in anger. And I always tell them, look, as your lawyer, please feel free to vent your anger on me. It doesn't matter what you say to me. Whatever you say to me is in confidence. It doesn't get repeated unless you want me to repeat it. And please, if you're angry, phone me up and give me a good blast of your anger. Don't do it with the social workers, because that really doesn't gain anything. With the social workers, and if you have clients who are dealing with social workers, being nice, being as friendly as you can be, being open, being cooperative, all of those things help, sometimes more than they probably should help, but all of those things help you in dealing with the agency. But you don't have to be that way with your lawyer. Please emphasize with them. You want to give someone a blast. Your lawyer is a safe person to do it to. What else have I got down here? My note to myself says that, dealing with agency counsel, then if you're a lawyer dealing with agency counsel, or if you are if you're advocating for a parent who doesn't have a lawyer, and you have occasion to speak to an agency lawyer, recognize that they can be a real friend in this process. They're not the enemy. And sometimes just knowing that and having sort of that mindset can make all the difference. It isn't a fight. It isn't about, finding out how many mistakes you can find that the other side has made. But dealing with parents, my note to myself here says, dealing with parents, this is often the most challenging and potentially the most rewarding part of the process. It really is. It is very, very challenging dealing with some parents, particularly initially, because they're in pain, and their pain is manifesting itself in anger. And that anger is just being directed all over the place. And it's very rewarding to begin working with people who are at that stage and end up sometimes after a further apprehension or an extension of that apprehension, 2 or 3 temporary orders, but to end up at the end of it with reunification, or at the very least with having those parents playing the optimum part as a parent in their children's lives. It's incredibly rewarding. Now, the other thing that the other group of people who, as a child protection lawyer, I deal with are children. Sometimes the masters, or sometimes at a later stage, the judges will appoint. Section 34 of the Child and Family Services Act allows for the appointment of counsel, appointment of a lawyer to represent a child who is 12 years or older who has been apprehended, to find out their position. And sometimes those appointments are made on an instructions basis, often with an older teenager, so that if I'm appointed for an older teenager on an instructions basis, I have to meet with that teenager, either in person or sometimes on the phone. Well, these days, I guess we're back to in person. And then they tell me what they want, how they want to see it. The agency wants a 6-month order, and they're saying, no, I want to go home now, or no, I'm okay with a 3-month order, but not a 6. So then it's my job to take their position to the court. In other cases, though, I'm appointed on what's called a best interest basis, where I'll meet with the child. This is usually with a much younger child, or a child who has perhaps some cognitive challenges. And I'm appointed on a best interest basis, so that I talk to the child and I look at the whole situation. I talk to the agency lawyer, and I talk to lawyers, of the parents, and so on. And then I have to provide the judge with what I think is in the child's best interest, so that even if the child may desperately want to go home, but clearly for a whole bunch of reasons, that's not possible, I will present it in such a way that shows for the parents that, look, your child really wants to be back home with you, but given the challenges that parents are facing, or often the challenges that the child is facing, if the child is in some specialized treatment facility, perhaps, that, that's not possible for now. And so I think I'm going to suggest to the judge that it's in the best interest of the child to, to remain in the care of the agency, at least, on a temporary basis. I think sometimes when lawyers are asked to speak with children, it really is a challenge. And, some people think that, I've heard people say, I can't talk to kids. That's not true. Everybody, all of us, can talk to kids because we were all kids once. And by that, and so what I say to people is, look, think back and, reconnect with yourself when you were 13, 14, 15. Like, remember how you were then. Remember how the world looked then. Most of us can, and we can look back to stressful or traumatic experiences that we had when we were kids, and we can kind of bring back those feelings. It's almost like it was yesterday. It's kind of scary, actually, but it's almost like it was yesterday. Now, okay, that's step one. Do not then, I always say, don't then think, okay, now I know how to talk to kids, and kind of revert to your childhood self and talk to the kids as though you're one of them, hey, bud, so, how's it going? No, that doesn't work. What you do is you think back to how it was for you then, and then you think, how would you like an adult to have talked to you then? And sometimes we can remember how a particular teacher or a parent or an uncle or an aunt, or very often a grandparent, how they talked to us when we were there. Remember that, talk to the kids that way. Everybody can do this. And it is so rewarding to see kids open up. I've had the rewarding experience many times of being in a courtroom, and there's some poor youngster there, they've been dragged to court by the social worker. Well, not literally dragged, but they're certainly there under duress. And there's a judge up in the front there asking them questions. They're absolutely terrified. All they want to do is go home. And so they just stand there and say nothing. And then I'm asked by the judge if I would speak with this young person. You go into a meeting room, you close the door, you talk to them like you would have liked to be talked to if you were in their situation, and then you watch with amazement as they come out of their shell and start to talk. It's an experience everyone should have, and I think it's an experience that we all can have. What else have I got down here? I'm going to have, by the way, I'm going to have a real axe to grind with my colleague who was supposed to share this hour and a half with me. I won't make it through the hour and a half, I can tell you that.
Maybe now is a good time
yes.
to jump in. Sorry to interrupt. Maybe now's a good time to jump in with a question.
Sure.
And by the way, some people have shared what it is that they do for work. So we have one person who said that they work in a community organization helping people living on low incomes, often single parents. We have a law student here, and we have somebody who works at a supervised access agency as well.
Great.
So somebody is asking, they wonder if there's information out there for grandparents and what they can do when the birth parents are deceased or otherwise unavailable to provide consent. Are there steps that grandparents or other family members can follow to obtain birth certificates and to secure guardianship of the children?
Okay, really good question. Grandparent access, couple of things. Grandparent access has fairly recently become something that is that the courts recognize. There is a process for getting grandparent access, and certainly grandparents very often can apply successfully to become guardians. That's not an area of child protection work that I'm involved in, but there are lawyers who are involved in that area. And what happens, this is not an uncommon question. And so I refer to one of the lawyers who, I didn't say specializes, but who I know does a lot of the grandparent access and guardianship application work. I'm sure he wouldn't mind me mentioning his name. I should have his phone number and I don't have it, but let me just write his name down, make sure I'm spelling it right. And incidentally, he's not the guy who didn't turn up tonight. So his name is Louis Godry. That's Louis. And his last name is Godry, Godry. And if you contact him, say that I referred you to him. He will, and I'm sure he'll offer you a brief consultation. But yeah, he definitely does the grandparent guardians, and I know he's keen on the grandparent access, because I represent a father on a file where he's currently representing a grandparent and doing a great job of getting access. The other question was about other family members, and that's sort of a segue into some of the exciting stuff that's happening with the Indigenous agencies these days. They really are blazing the trail. They really are shining the light into the future in a very, very positive way. There's some new legislation, Indigenous legislation, where they lay out their philosophy and their focus, and they are very much focused to, wherever possible, first of all, not apprehending, keeping children with the parents. And if it's not possible to keep them with the parents, then searching for other family members, extended family, who are able to step up and who are able to parent. So that's, you know, the old idea of, you know, children being apprehended and then permanent orders, and then when there was a permanent order, the door slammed shut and that was it. That is a thing, thank goodness, is a thing of the past. And again, that's been pioneered by the Indigenous agencies, who basically are saying, look, even when we get a permanent order, and I've heard agency lawyers say this, even when we get a permanent order, permanent does not mean forever. Always the hope always is reunification with the parents if possible, or if not with the parents, then with immediate family. If not with immediate family, then with extended family. And if not with extended family, then at least within the home community. So that was a great question.
Thank
Nina,
you.
are you still there? Yes.
Yeah.
Anything else?
Yeah, the person that asked that said, thank you. I appreciate that referral and information.
Okay.
I just have a follow-up question. I know when I was in private practice, I had a lot of questions about what is the difference between permanent guardianship and adoption. And perhaps for someone who has maybe had a foster child for a long time and they are looking to make that permanent, what are the pros and cons perhaps of each?
Okay, so well, first of all, a guardianship, you know, okay, so a permanent order of guardianship with an agency means that the child becomes a permanent ward of that agency. But permanent orders can be rescinded or set aside, and I've recently had that happen in a number of cases, where the parents are now in a position that they can parent. They previously weren't, but they're now in a position where they can parent. And so an application is made in court. Sometimes the agencies themselves will bring that application. Sometimes some of the agencies will have the parent's lawyer bring the application, and those orders are set aside and the children are returned to their parents. That is not an uncommon thing. So that's where children become permanent wards. Now, where guardianship is where private individuals become guardians of the children, then you are looking at a different situation, and one which, quite frankly, I am not familiar. That's much more an area for family law, and I don't practice in that area. So if you ran into a situation where there was someone had guardianship of a child, permanent guardianship, and the parent was wanting to have the child back in their care, then it would be a good idea to consult with a family lawyer, and any one of a number of the family firms could certainly help with that. That's kind of out of my area of practice. With the now that was only part of your question. There was another part. There was another. What was the rest of the question? That was setting aside the order, but there was.
Yeah. So the second part of the question was, how is a permanent order of guardianship, whether private or as a ward of CFS, how is that different from adoption, perhaps?
Okay, different from adoption. So adoption is final, and you know, with adoption, the door then is closed. It is then as if that child who is adopted is it's virtually the same as if that child is the birth child of those parents who have adopted. So that's different from the guardianship. Guardianship means that whoever has guardianship is the legal guardian of that child. Adoption means that the parent is the adoptive parent of the child. So sometimes for instance, used to do this a lot before the Indigenous agencies stopped doing adoptions, and they do not do adoptions. With the general authority, they do still sometimes want to have adoptions as the case plan after a permanent order. Sometimes what we will do when a parent is agreeing to a permanent order, they will do so on the condition that the agency for at least 1 year will not place the child on the adoption list, because for 1 year, any time after 1 year is when the parents can go back to court to get that permanent order set aside. But once the adoption happens, then that's it. So that's the difference. The adoption is final. The guardian, the permanent order of guardianship is not.
Okay, thank you so much for answering those questions. I think those are all the ones that we have for now. So I'll interrupt you if we get any more.
Okay, I'm. How are we doing for time? Oh, that's good. We've got through an hour, guys. That's pretty good. Okay, let me see what else I've got here. Well, I've got preparing for trial. That's well. I mean, this I think will be. This I think might. You know what? I'll just very quickly. And as I say, I had initially thought that not only was I going to be doing this with other counsel, but also that the audience would be lawyers. So I went into fair detail with the trial stuff, but I won't do that. But what I will do is just briefly talk about trials. There was a period of time when I think all of us who were operating in this area, all of us who are practicing in this area, why did I say operating, practicing in this area, sort of assumed that if things went to trial and there was a parental capacity assessment done by an expert, that is to say by a psychologist or sometimes by a social worker, but usually by a psychologist, there was a feeling amongst many of us that, basically once that parental capacity assessment was done, and once the assessor, the expert, had given their expert opinion as to whether or not there should be a permanent order or a temporary order. Usually these were done in anticipation of a permanent order. That once they had given their position, then basically our feeling was that the judges just sort of followed the experts. Insofar as we seldom, I don't ever recall seeing a case where the expert on the parental capacity assessment said there should be a permanent order on this child. I never had the experience of having a judge say, well, actually, wait a minute, let's look at that. Let's look at this assessment, and maybe the assessor has it wrong. But I have to say that things, again, there are a lot of things that have changed for the better in the area of child protection. And this is one of them. As I say, one of the trials that I had in which I was involved last year, it was just the assessor had cut some corners. The assessor had it was a poor assessment, and so during the course of that trial, lawyers for the agency, one of whom was me, were able to cross-examine this expert, and were able to, in fact, tear some really significant holes in his assessment, to the point that the judge, in her final decision, made it very clear that she was not following that assessment. So, things have changed. So I would say that all I would say to the lawyers is, if you go to trial and if you've got if a parental capacity assessment is part of the package, take the time to really pick that apart, go through it, ask yourself the questions, really pay attention to the little things, So you've got an assessor who says that, your client, had a poor visit with the child, didn't display good parenting skills in the visit. Really take the time to look at it and ask the questions. Was the assessor there for the whole visit? Or in talking with your client, did the assessor actually arrive late to that visit and miss the part of the visit where the parent greeted the child and watched the child's reaction to seeing the parent? And was the assessor there in the part of the visit where the parent was feeding the child? And then look at the other comments that the assessor makes in reaching their conclusions. Particularly, this is important if you're dealing with, if your clients are newcomers, or if they are perhaps not even newcomers, but are a part of a cultural group that maybe doesn't see things quite the way that your assessor might see them. It's really worth taking the time to go through those assessments. A lot of them are just sort of boilerplate stuff, but really go through and take your time going through them. The other two things I have, I think I've just about exhausted, Nina, what I had to say. So I've a couple of other points here. I've got staying organized. This is, I guess, for all of us, I say figure out a system that works for you and stick to it, unless you decide to make refinements and then stick to them. And I think that's a bit of a confession on my part, that sort of sharing some mishaps of my own. I tend to come up with systems, sometimes more by accident than design, and I follow them, and then I decide to change them, and then I forget the changes I've made. So I think that in this kind of work, it really is important to stay organized, but that doesn't mean that it has to be in any kind of traditional way. I was in court yesterday, I think. Monday. I was in court yesterday with a lawyer who spent a lot of time telling the judge about all this sort of technological way he has of keeping records and so on, and he didn't need paper copies of this and that and the other. And I was intrigued by it. I understood very little of what he was saying, and I told the judge that and told him that. I still use paper. I still have a paper diary where I write things down with a ballpoint pen. I find that's big enough that I'm less likely to lose it than I am my iPhone. It doesn't matter. Whatever works for you, stick to what works for you. And if you make changes, remember the changes you make. But don't necessarily just feel you've got to it can easily be a square peg in a round hole if you're just following somebody else's way of doing things. Figure out what works for you and do it. What else have I got? My final thing says, my final comment is, be kind and considerate to everyone involved in the process. And then I've got in brackets, especially yourself. The one thing I've found in working over the years with people who are helping people, whether it be in any of my previous careers, and you can see I couldn't, if you as you've already heard, Nina outed me on that. I've been unable to stick to anything through my variety of careers, although I like to think I've taken all the skills I've learned in each one and used them in the next one. But the one thing that has come across again and again to me in working with people who are helping people is how generous the helpers are, whether they're lawyers or advocates or visit supervisors or whatever other role they may have, how generous they are in dealing with the people they're helping. The visit supervisor says, it probably wasn't great that they made that comment as they left, but you know what? It must be tough for them leaving the kid at the end of the session like that, So generous in the way that they interpret the words and actions of other people. Those people are so hard on themselves. You make one little mistake, and we all make mistakes. You make one little mistake and you take it home with you and pound the crap out of yourself. I mean, A, it's done and you can't go back and fix it. B, it's probably something you won't do again. And C, you know what? If that was anybody except you, you would never be that hard on them. So ease up a bit on yourself. Give yourself a break. And subject to any questions, Nina, I think I'm done.
Okay.
Oh, hey, hey, Pepper, come here. I was going to have my dog sit up here with me. But she's sleeping now. She won't come. Anyway, but nice to see your cat. Yes.
So thank you so much for that engaging and compassionate overview of child protection law. If anybody does have any questions, now is the time to put them either in the Q&A or in the chat. I do have a follow-up question actually about parental capacity assessments.
Yeah.
For a parent who is sort of anticipating going through that, what should they expect from the assessments? And is there anything that they can do to sort of prepare themselves for the assessment?
Okay, no, that's a really good question. I think when people know they're going to be tested, they always think, well, maybe there's something I can do yet to prepare. So sort of cramming for the end of term test sort of thing. And no, the assessment itself, there are a number of components to it. Often it involves some sort of written stuff, and I don't mean writing an essay or anything like that, but sort of checking off what you prefer, the following, or that sort of thing. There'll be the assessor will want to talk about parenting, and talk to the person about their own history and experiences, try and get a feel for that person. They'll have access to the agency's notes, the agency particulars. They'll also want to watch usually at least one visit between the child or the children and the parent. Sometimes that will be done, behind a two-way, a two-way mirror, where they're behind, where they're out of sight, and they usually will spend a fair amount of time talking. Now, what I would say to the parents is, I don't know if any of the lawyers involved here, but I know myself when I was when I had a criminal practice, I mean, the one thing you say to your clients is, don't talk. The police want to talk to you. You say, on the advice of no, you don't talk. Less is always better. But with an assessment like this, and I would say really in dealing with the social workers, like I would say, be honest. Be as open and honest as you can. This fellow who came in to see me today, when he came in, he was very uptight. By the time he left, he was relaxed, and he actually smiled. He had a great smile. And I said, when you meet the social worker, and the same will go for when you were doing an assessment, like, be like this, like, and try and relax. And these people are not your enemy. They're not trying to keep your children away from you. They are genuinely trying to find out about you, and about your children, and about what, if anything, needs to happen before you can be reunited. So the more open and honest, I mean, having said that, this is an assessor. It's not it's not your priest. You don't have to sort of dredge up everything you can think of bad to say about yourself, but just be, answer honestly and try and be as relaxed as possible. There really is no way to prepare as in cramming for the LSAT or, the end of term test.
Okay, that's a great answer. One more follow-up question here. So you talked a lot about reunification and that
Right.
sort of being the goal of child protection. So what happens under circumstances where you mentioned, children as they are over the age of 12, the court might take into account some of their views and their preferences in the situation. So what advice do you have for parents or for lawyers who are perhaps dealing a situation where the child is opposed to the reunification? Because I can imagine that would be hard to deal with from a parent's perspective and also as a lawyer.
Yeah. And certainly that happens. I should also say, and let me, without losing track of what you just asked me, because that's important. There are cases, and certainly I have had a number of them over the years, where my client, the parent, is, for no fault of their own, unable to parent now, and probably will be unable to parent for the foreseeable future. And and where the parent, and almost inevitably, it seems in those situations, there is a grandparent or someone with whom the child has been living where that, and that can continue. But the point is that the parent has to make the difficult decision to consent to the order. Consent sometimes to a temporary order, sometimes to a permanent order. And I've heard judges say with the greatest sincerity to those parents, you know, this is a wonderful gift that you're giving your child. This is a great thing that you are doing. And it really is in some situations. You know, hopefully they can continue to be involved. And very often, parents who are never going to be able to parent, as in taking full care of the child, will be able to remain involved in the life of that child and maybe become even more involved down the road when the child is older. And so, you know, an order, even a permanent order, is not necessarily always a bad thing. Reunification is always the goal where possible, but reunification may only be to an extent rather than full reunification for now. To go back to the question of, okay, the child who says, there's no way I want to go home. I hate my parents. They've been mean and horrible to me. And yeah, they're saying they'll change, but I've heard that before and I don't want to go home. Those are difficult situations. They're situations where one hopes that the child and the parents are going to have access to some counseling, some therapy. Time can sometimes be a great healer, particularly with kids, because they're not always going to be like they are at that moment in time. And kids can change very quickly, and their lives can change very quickly. But in those situations, though, Nina, where you have a teenager who says, I don't want to go home, there's usually a very significant history to them taking that position. And frankly, in those situations, the agency cannot return a child to parents if the child is refusing as a teenager to be returned. I mean, how do you do that? You know, but those are hard situations. But they're usually hard situations with, as I say, a significant history. It's not like for one of you guys who sort of trying to imagine that, you know, your child would tomorrow decide, okay, I don't want to be with you anymore. I mean, there's always a history. And where there's a history, there's always the potential for a future. And that means that you've reached this point and things can change. And kids change.
Okay, I think that's a great answer. It doesn't look like there are any other questions. So you've made it an hour and 20 minutes. So perhaps we'll today. Once again, I would like to thank David Joycey for being here today. We are so honored to have had him present. And also thank you to all of our attendees who were able to make it this evening. So thank you once again, and I hope everybody has a wonderful evening.
One thing, Nina, can I interrupt you? Absolutely. One thing I would like to do, and this is not because I'm kind of fishing for business, but just I know that if these people are working with people who may at some point, it might be helpful for them to know how to get a hold of me. Let me just say my phone number before I sign off. It's 204-232-5261, and you can get me anytime at that number. And there's no such thing as a silly question. Please feel free to phone if you think I could be helpful.
Thank you so much, Mr. Joycey. We appreciate that. And thank you again for being with us this evening.
You're welcome.
Okay,
bye for now.